Welcome to the IPP Web Conference, CCPA Readiness Blueprint, How to Effectively Scale Your Privacy Program in 2020. Brought to you today by Wirewheel. My name is Dave Cohen. I'm the IPP's Knowledge Manager, and I'll be your host for today's program. We'll be getting started with the presentation in just a minute, but before we do, a few program details. Participating in today's program will automatically provide IPP certified privacy professionals who are the named registrants with 1 CPE credit. Others who are listening in can apply for those credits through an easy-to-use online form on our website. We'd also like to remind you that today's program is being recorded and will be provided free to registered attendees approximately 48 hours following live event. We encourage you to ask questions at any time during the program by typing them into the Q&A field that's just to the right of your PowerPoint window, and we're going to answer your questions throughout and during a designated Q&A session that's just at the end of the presentation. And now on to our program, and I would like to introduce today's panelist. Justin Antoni-Pillay is the CEO of Wirewheel and former acting Undersecretary of Economic Affairs for the U.S. Department of Commerce. Justin, it's great to have you on the program with us today, and can you tell us a little bit about your current post over there and Wirewheel and how you got into the space?
Dave, thanks so much for having me. Always enjoy a conversation and to talk to the community that comes to these IPP sessions. We always have a terrific conversation, and the questions we end up getting are thoughtful and from very deep practitioners in the area. As you mentioned, I'm the CEO of Wirewheel. Wirewheel is the privacy platform that has really been built for both privacy professionals and IT teams. We have a full set of solutions that cover helping to automate your subject rights systems with your consumers, everything from handling opt-out of the sale of data under the new California law, access, correction, deletion at scale, with a very nice way to stand it up quickly and ways that you can mature your program over time. And we also have offerings to help privacy professionals automate and scale the different kind of challenges they have every day with very small budgets and small teams. So data discovery, data inventories and data flow mapping, and even assessment automation is something that the privacy program management platform we have on Wirewheel is set up to handle. I'm delighted to be here today and to talk a little bit about how we can think about getting ready not only for CCPA in the next couple of weeks and months, but how we can mature that program over the next year and 2 years with you.
Excellent. Thanks, Justin. And so with that, let's go ahead and get started with the presentation. And this will be a live and interactive session. Once again, as I mentioned at the top of the program, for those of you on the line with us today, we have a healthy online audience. We strongly encourage you to submit your anonymous questions in the field that's just to the right of the PowerPoint. And we're going to deal with those throughout and leave some time for them at the end as well. So Justin, it's all yours.
Terrific. And we're going to focus on education today. As I mentioned, from the Wirewheel perspective, if you'd like more information on our platform, you can go to wirewheel.io/demo. It's at the bottom of the page as well, and we'll give you more information on the platform itself. We have been working with companies over the last, really the year, and then going back 3 years on GDPR, on how to think about really getting set up for version 1 on CCPA, and then understand how you're going to need to mature that program over the next few years, Dave. I'm always empathetic to the challenges that privacy professionals have in their day-to-day lives. Even now, several years into GDPR, I see in almost every company an incredibly dedicated group of professionals on the privacy side who are not only helping their companies day-to-day manage that program tactically, but privacy has become such a huge strategic issue for almost every consumer brand we're working with, and certainly if you're in certain B2B worlds like the MarTech or the AdTech world, we see privacy professionals becoming an absolutely core part of every company's long-term strategic and tactical goals. I think Dave and you at the IPP probably get this. I can absolutely see CCPA and these other laws driving an incredible amount of hiring over the next year in the privacy world.
Well, it's absolutely true, Justin. Yeah, we're expanding here at the IPP, and there are increasing requirements. It used to be a few years ago. You and I have both been in the space for a while. You know, there was GDPR, the big ramp up to the GDPR, and then CCPA. And I think at this point, people are like, well, this is not the end either. There are other regulations coming down the pike as well.
Yeah, that's right. And in line with the challenges and the opportunities in the privacy world, there's some honest resource and technical challenges we see companies have every day. Privacy offices are very small still, as a general matter, compared to our compatriots on the security side and the IT side. A lot of the information that our teams need to do our jobs are in the minds of people all around your organization. It might even be in that technical stack, you know, in the data stores or in your infrastructure or in SaaS platforms. And although a lot of organizations are focused on getting our community up to speed on technical background, there's a lot to learn, and we all have limited time to do it. You know, understanding the entire MarTech and AdTech world, and even things as simple as how cookies function. Every day I talk to privacy professionals in that world, and they tell me it takes 1.5 years to just become really up to speed with what happens in the MarTech and AdTech world. And that's a hard burden to put on our privacy community when you're just trying to do your job in other ways. So what we wanted to start with today is, how do you start fast, even if you haven't planned right now for CCPA? And we do. We have companies coming to us every day. How do we start by getting up version 1 of CCPA? And then the real focus for us in this conversation today is, where should you be spending your time on being prepared to mature up and invest more in light of some of the things that are coming next year? So let's start with this overview, Dave. There are minimal things that you want to do ahead of January 1st. And what we think about with our customers is, how can you at least be able to tell a proud story up on your websites, and to have at least some planning done internally for your companies in the next month to 2 months ahead of CCPA going into effect. And so while there are a lot of things you need to do, there are also some ways you can tackle it, and that we can get you stood up from a privacy program to get in front of it. So number one, we strongly recommend that you set up something on your outward-facing website that's dedicated to CCPA, especially if you are a consumer-facing brand, or you're in the MarTech world, or you're doing something with data you collect from individuals that arguably could be a sale of data. So on one hand, the Attorney General in California has said very publicly they're not going to start enforcing under CCPA until July of next year. They've also said they're going to look back from July, at least to when the law went into effect, to January, to make sure companies are really trying to implement and enable their customers to take advantage of the new rights under CCPA. So minimally, we like to say, do something. Just do something. Put something up on your website that is a place your customers understand that you are on top of CCPA. You might want to give them some way that they can register a request to you for data if you are arguably covered. If you're on the privacy side of the house, please go talk to your marketing teams and the team that might have manage your CRM, like a Salesforce, just so that you have some understanding and connectivity to those teams, so that if you start getting requests under CCPA, that you have contacts in those groups and you know who to call when something happens.
Hey, Justin?
Sure.
Yeah, so a quick question here. Something that we hear frequently at the IAPP, and I know I'm going to guess a lot of folks on the call are wondering about if they're participating in the program today, and that is they're trying to stand up a program and they're wondering in advance of this law taking effect and consumers exercising their rights, they're wondering about volume. You know, how do I know if I'm going to get these requests in dribs and drabs, you know, one-offs, or if, you know, the January 1st date's going to come on January 2nd, I'm going to be inundated with requests and therefore would want to be working on building for volume. Do you have any advice on, obviously it's a general question and each organization is going to be different, but any general advice on how companies can think about whether they should plan for scale or maybe start off assuming they're going to handle these as individual events? I'm sure you hear this as well.
Dave, we hear this all the time. I think anybody who has who believes they have a full crystal ball, I think it's hard to know at that level, so I agree with you completely. There is a lot of focus from the California regulators and from some of the privacy advocates around B2C companies, especially where there's location data, healthcare data, or that sort of thing involved. I think there's been a lot of focus from the regulators and from that community around MarTech and ad tech companies that are arguably selling data. And most of the models we're seeing when we're working with some of the biggest consulting firms and others is assuming that there's going to be a higher volume of both opt-out requests, certainly opt-out of the sale of data requests, and then a higher volume of access requests and perhaps deletion requests than companies received under GDPR. Just how much larger the models I'm seeing that folks have, they're expecting a much, much higher set of requests under opt-out of the sale of data than they might for access or deletion. But even on access and deletion, companies that fall into the windows that I've been talking about seem to be expecting, you know, orders of magnitude higher over some window of time after CCPA goes into effect. I think a lot of this will depend on just how much advertising and advocacy comes from both the Attorney General's office, the privacy community about where companies should go to make those requests. But generally, folks assume that the numbers will be higher and materially higher when it comes to the opt-out of the sale of data. Are you hearing the same thing, Dave?
Yeah, so perhaps what I'm hearing, Justin, is if you want to take the more conservative approach, probably best not to assume that they will be, you know, singular events and one-offs and something that you can handle individually. Perhaps better to prepare now for dealing with volume and scaling up so that you're prepared for that, which seems inevitable eventually anyway, rather than to just maybe take a road where you think, oh, we'll tackle them, you know, individually as they come in, and hopefully we won't get that many. That might be a more risky approach.
That's right. You know, look, the privacy community, I think, regularly we face this worry where people are throwing up red flags and calling that it's going to be a disaster. We don't like to take that approach. What we say is at least think about the major places you're going to need to go if something does happen. And I'll talk through that in a minute in terms of version 1. We like to bucket where you think about these risks into what you're seeing on the screen now: the right to disclosure and access, the right to deletion, and the right to opt out of the sale of data. I'm going to focus on the right side of it for a moment, Dave, because there's this area when you talk about the right to opt out of the sale of data. My sense is this is where companies are going to get hit more and with higher volume because of the way both the law is written and the way that the proposed regulations are written. And I like to remind on a constant basis that although there are draft regulations out, the comment period on those has just expired, and we don't even have a final version of those regulations. So you want to make sure you're in a position where you're looking at the regulations but not over-indexed to those proposed regulations because they aren't final yet. But if we could talk about the opt-out of the sale of data for a minute, Dave, most everything, even set aside the language of the law and the regulations, almost everything in CCPA talks a lot about this. And there are two things to consider here when you're trying to figure out what to do. Number one, sale of data under CCPA is very broadly written, just in the law. And when you see the draft of the regulations, it seems to broaden it. So regularly I'm asked, well, we don't actually sell the data, or I'm more of a processor, to use the GDPR language. Maybe I don't need to be posting that do not sell language. And if you actually look at the law and you look at the proposed regulation, a lot of the things most companies do, even when it comes to cookies, qualifies, or strongly qualifies as a likely sale of data under CCPA. So there's a good chance, and you should talk to your own lawyers, I don't want to overstate this, but there's a good chance in your company there's stuff going on that qualifies as a sale of data, and it may be hard to eliminate that you're doing that. So the result has been, with many of our customers and companies we're implementing on our platform, the safest way to go is to actually just at least post a do not sell link, set up an infrastructure to be able to capture that link in the right way, and then at least you have a suppression list based on the request to opt out. And as the regulations develop and as you see where things are going, you haven't missed the opportunity to capture a do not sell request along the way.
So Justin, I think,
yeah. Sorry,
I was just going to say, I think this may be a good place to, pause and underscore or underline the point you just made, because it's a significant point of discussion within this new law, this idea that sale doesn't necessarily equate with the traditional definition of sale and exchange of data for, some kind of financial remuneration. It can be more broadly interpreted. I think this is something that a lot of companies want to pay very close attention to. To your point, it could be easy to think, oh, well, we don't sell information, we're fine, we're not going to therefore take any actions here, where that's maybe not the best approach and could be risky.
That's exactly right, Dave. I mean, here's a question that if you're trying, some questions that you might ask, if you're a privacy professional, to at least try to think about whether you might be selling data. If you go to your marketing team, and this again is where building those relationships now can be so critical. I tell most of my colleagues that we're working with and partners and customers, go buy lunch for your marketing team. Just go talk to them, engage with them. Because here's a good question. Are you dropping third-party cookies on your website? Because just think about that simply from a privacy professional. If somebody comes to your website and you sell shoes, and when somebody comes to your website, there's a third-party cookie dropped for a non-shoe company, and that enables some sort of insight to go to the third-party non-shoe company, and you look at the language under CCPA, there's a pretty good argument that that qualifies as a sale of data. And so the problem I'm identifying for now is not that everybody has to rush out and panic. It's just when the law, if you're covered by CCPA, the law basically says if you are selling data as is described, you have to have a do not sell button and you have to be able to capture it. And what we've seen as a practical matter is that if you're a CPO and you have to try to eliminate that you're selling data, it's really hard to do. And so at least putting something out that allows you to show that you're saying that you have a do not sell link, that you show that you're capturing a suppression list, and we can figure out where this all goes, has been where we ended up with a lot of companies, just because as a practical matter, it's very, very difficult to figure out, to eliminate all across larger organizations whether something is happening that qualifies as a sale of data.
Makes good sense.
When we and by the way, this can cover service providers too, not because of necessarily your relationship as a processor, but a lot of service providers we work with, if you even go to their main website, they're doing third-party cookie information on their website. So again, it may be that the do not sell might be captured by your customers if you're purely a vendor or processors. But when you look at what your own team is doing to market, often we found that they're technically selling data within the meaning of the act, which means you need to think about a do not sell button as well.
I'm glad you said that, Justin. We just got a question from the audience. And by the way, please keep the questions rolling in if you're out there listening, and just type them in the field to the right of the slides there. We received a question about our service providers required to post a do not sell link on their website. So I'm glad you tackled that.
Yeah, I mean, the answer you'll see in the act is if you're definitely not selling data, you don't need to post it. The trick is what I was saying. Just try to find a way to either really document and eliminate that you're selling data, or the safest thing is to do some kind of a do not sell button. And again, there are technical things you're going to want as part of that. It's not merely posting a list, but you need to capture that information, and then you're going to want to be able to share your suppression lists in the right way. This is the kind of technical infrastructure that we tackle on a regular basis. So I'm going to pivot for a moment on right to opt out of the sale, and I'll just close that point for the moment by saying the standard that is put in Ccpa and in the regs for how easy it should be to record and opt out of the sale of the data, it's very, very light in terms of making it very easy for any consumer or any person to request it. And you can see that this is getting even more broad over the next year. And we're going to talk about this later in the session, but we've all seen that the Californians for Consumer Privacy are already putting out another ballot initiative, sometimes called Ccpa version 2.0, and that makes it even broader what a sale of data is, and is supposed to make it even easier to take an opt-out request. So the next thing we end up focusing on with companies in both version 1 and where are you going to mature is how do you ensure that you are able to handle a request for access of data from the beginning all the way to the end. And so this is an example of how companies should think it through and think about where you should invest in making sure you have process and technology behind it. Again, we can consistently say it's not necessary to think of the most mature version of this, but this is meant to be an issue spotter for companies to think through. So first of all, of course, you're going to want to be able to transparently publish information to your customers about their rights under Ccpa. And remember, Ccpa focuses on certain categories of information that you might want to put into your privacy notices and privacy policies and have at the ready. Those three critical categories are categories from where you collected the data, so you have to be able to know if you're buying data or collecting it from partners and publish that. You have to know categories of third parties with whom you're sharing data, and you have to be able to publish very simple, easy, understand categories of the data you're collecting about people, either buying, acquiring, or others. So the biggest challenge we've really seen with our privacy community on this first one is, and where you might want to mature over time, is building the first version and getting it up on your website. I think obviously every company has had to do. Being able to maintain this from the privacy office can be a real challenge, honestly. We found most of our privacy professionals don't have regular access to web development resources. And so every time you have to change this or mature this, we find our privacy professionals running around their organization to find web development resources, or you need to go to your IT team. So that's where technology can help, but that's one of the main things to think about maturing over the next year. You need to have a way, of course, next to allow a consumer to submit a request. And along the way, this is for access of data, many of the bigger companies we work with, you're going to have customers requesting different levels of sensitivity, different levels of information in terms of their sensitivity. So some folks that come to get data from you, you may have never had a relationship with, they may have no account with you, and the data you may have from them may not be that sensitive. But a lot of companies, they have that kind of request, and then they have folks coming to get their data where you might have very sensitive data about the requester. So having a way to sort between the most sensitive and the least sensitive, and then authentication and verification is a place. You just want to think about it, and over the next year, likely mature your program, because in GDPR, the burden is, I'm sorry, CCPA, I apologize, Dave, but in CCPA, the burden's really on the company to make sure you've done enough before you turn information over to somebody. So you have to make a judgment call, and even in the proposed regulations, they identify using things like verifying email addresses or mobile devices, doing ID checks and selfie checks, things like affidavits or affirmations that you have to be able to take from somebody, being able to do even challenge questions along the way. These are only options. Almost every company we work with knows there's no perfect solution, but each one of those requires some technology behind it if you need it. And
hey, Justin?
Sure, yeah, go ahead.
Yeah, I just wanted to ask you a question about this authentication, because I think this is another thing we here at the IAPP are hearing discussed a lot. It's to try to get this right. There's a balance to be struck between making sure that you're not giving out personal information to unauthorized parties, and at the same time, you don't want to create too much friction for the consumer requesting the information, because that's not going to sit very well with the consumer either. So this is a pretty difficult thing to do, right?
You're absolutely right, and we're not going to be able to cover all of this today. One of the things we've made available to the IAPP community with much more balance and nuance, Dave, is if you go to wirewheel.io/RFP, we've laid out a document that has a lot of the technical requirements with some balance that might be more helpful for the community of how you balance one against the other and how you think about these things. And that's a resource that is much, much deeper, but you're really right. It's not about having a one-size-fits-all set of challenges. It's about thinking through the sensitivity of the data, making it easier for a consumer to get that data if it's not as sensitive, and being able to have assurance that you've done kind of everything you can with consumers who are, in fact, getting much more sensitive data. And that's why, as we go through it, it's not a one-size-fits-all. We need to have choices within your company that allow you to verify and authenticate the requesters, and depending on the kind of data request. You're going to want to think about actually having some way to assign out collection within when you're collecting data. Some companies, you start by just having safe encrypted environments to collect data via workflow. You want to at least think about that if you happen to get hit by hundreds or thousands of requests, how can we start automating that? And that's a critical conversation we're having with a lot of companies about how we might mature this over the next year if they start seeing a high volume of requests early next year. And again, this is where we like to have balance with our community. You remember, even if a request come in on January 1st, you have until at least the middle of February to fulfill those first requests. There's a 45-day window. And then on top of that, if you have good reason, you can get another 45 days before you start fulfilling requests. So while we want to make sure our community is thinking about this, that you've looked at the primary places you want to collect, you at least think about the way we can start automating this. If something weird happens, you do have a couple of months here at the beginning of the year to start tackling that if, in fact, it really gets to be a high volume. Encryption is absolutely critical. As we all know, under CCPA, there's breach liability and privacy liability. If you fall into the breach liability area, you're subject to class action liability and a lot of elevated risk. But there's a safe harbor in CCPA as long as you encrypt the data. So what we're really focused on with our community is making sure that when you're fulfilling these requests, it's encrypted all the way through so that you don't take on breach liability while you're, enabling consumer rights. And then, of course, you're going to need tracking and reporting. Both the law and the regulation have a number of requirements. In fact, you might have seen, Dave, in the proposed regulation, companies have to be posting the number of requests they're getting, how often it's taking to fulfill, and do that publicly. That can be a burden on small privacy offices, to track it down. So think about ways that you can automate that. I'm sorry, go ahead, Dave.
Justin, I was going to say, this is another point where there's a lot of discussion around, all right, more potentially challenging reporting requirements here for the CCPA. And, what we hear from a lot of our members is, well, we just went through this big GDPR lift, and of course the GDPR has some reporting requirements as well. Can you comment, Justin, on whether any of those efforts to, create documenting and reporting systems for the GDPR might port over to the CCPA and have that work leveraged, or are we talking about different enough reporting requirements here so that these are going to be new standalone efforts? Any chance we can leverage that earlier work?
Oh, you definitely can. If companies have spent all the time on PIAs and the GDPR preparedness, you've probably done a lot of the work. You've probably done a lot of the work in terms of identifying the systems, and that infrastructure that you've thought about, you can repurpose. There are enough differences that it's not like a plug-and-play thing, we found, because the specific reporting that you're going to need for CCPA is just a little bit different than what was required under GDPR. But that brings me to a critical point here, Dave, which is, we've seen a real change from the way companies are trying to tackle the first version of CCPA from the way they had to tackle GDPR. And the critical thing here is, because GDPR was very driven by assessments, you had to do these privacy impact assessments and these data protection impact assessments, and we can help automate those. The real thing here is a lot of companies, when you were all driven by assessments, it meant you have to really go and find everything, really find all of your systems and all of the data. And what we are finding is if you're looking to stand up a CCPA program, you can prioritize some of the critical systems that you'll really need to collect when you're fulfilling a CCPA request. And that's not a matter of saying you're not going to go look at everything later. It's a matter of prioritization. Because when we go into companies, you're going to want to start by collecting data from your main customer identity and access management center, if you have one. You're going to collect it from the main data stores that are driving your, your applications. If you have a CRM, like a Salesforce or something like that, you're almost certainly going to be collecting data from that system. If you have a marketing or analytics platform, that's another place where you're almost certainly going to want to collect information. So I've just prioritized for what we're seeing 4 critical areas that you're going to want to collect from first. And that means rather than going to boil the ocean, CCPA enables you to prioritize some of the systems and to focus on those first instead of trying to go find everything. So we made this slide available so that our community can say, okay, start with these main resources, make sure you've had basic conversations with the teams running them, Then when you get a data subject request or a subject request under California, you have an initial place to go, and if the volume starts getting large, we can figure out ways to automate it for you. So prioritization, to me, with a lot of our community is really important these days because we don't have the time, you don't have the resources to try and find every resource all across your organization to do CCPA compliance. And then, so we talked through getting a Do Not Sell button up and being able to record that. We've talked about the basic elements you're going to want to think about for access and deletion in these first few months. But now we're going to look at what comes next. How do we all think about not only be preparing for January 1st, and remember again, we have a lot of companies that are looking to wait to see what happens after January 1st all the way through July when enforcement starts. So here are some of the things that we are really looking to work with companies on. Volume, Dave, as you've identified, is critical. How does it look? How many requests are you getting for the opt-out of the sale of data? The amount of time that companies end up spending fulfilling this request is often very high at the beginning because you're finding the major systems and it's very human-driven. That can be a burden on your main marketing teams, your sales teams, your application data teams. So try to find ways that you can make it as easy as possible for them and at least go through some kind of a tabletop exercise to start. And what we're going to do over the next year is automate a lot of those things. Take the burden off of the human beings and automate the requests back and forth from these critical systems so that you don't have to call a human being every single time. The third-party challenge can be very tough. Just remember when it comes to a deletion request, for example, a company who is the one that is the face or the controller for collecting that information, you have to not only get some assurance that you're deleting it within your own infrastructure, you have to send downstream requests to third parties and document those. That can be a burden. There's just a lot of third parties with whom sharing is happening. Your third parties might include both, other software as a service platforms or partners. So think about how you will at least show that you are sending those downstream requests and think about automation behind it because that can be a really significant time, area for companies, and automation can do a lot for you there. And then for you, what type of requests are presenting the most risks? Are you doing a lot of marketing? Are you collecting the data for marketing purposes? Are you really going to have to change the way you do business based on, the opt-out of the sale of data requests? And I would direct that comment really to content providers. If you're a content provider and you're providing content or in some ways, both, it might be you're a consumer-facing company and you provide content as part of your marketing strategy. It might be that you're a true content provider. The opt-out rules really have a high chance of changing the way you may want to do business because if somebody opts out of the sale of the data, you're going to have starting to have conversations with your business teams around when can you charge for that data? Can you put up paywalls or other things that present a reasonable choice? And technical infrastructure there can be very, very important to that conversation. I always like to give you a minute, Dave, if you have any questions.
Yeah, Justin, actually, I'm glad you paused there. I did have a question I was just thinking about, which is, let's say that I'm an organization for the using GDPR language as a controller, and I've got a fair number of outside processors, as it were, downstream, service providers that are processing information for me. Again, this is a general question, just to get your general take on this, Justin. And some of those folks handle that personal information for me under my kind of explicit instructions. For opt-out requests and data subject access requests, is it more typical to direct my consumers to these third parties and have them deal directly with them for some of those opt-out and subject access requests? Or is it I'm going to have them do my bidding for me and get those requests back to me, and then I deal directly with the customer? In other words, how much triangulation do we want to try to have? I can see pros and cons to both approaches. If you offload that liability and responsibility to some of these folks downstream, maybe you can say, well, they're taking care of it, but then you're also losing some control. And what if those vendors don't treat the customers with the same kinds of respect that I would hope that they are treated with as being my primary customers? So I'd rather have that coming back to me, but then there are additional techniques and, information flows that I need to build for that. I hope that makes sense.
It does, and you're asking exactly the right question. I think the model that I've seen both from the AG's office, from the law, is really pretty similar to GDPR, in that if you're the one that collected the data, if you're the one that the consumer thinks of as the kind of controller, you're on the hook to make it easy downstream when there's a deletion request or an access request to get the data back to a consumer. So a lot of the companies we work with that are processors, B2B processors, what we set up for them is a nice automated system to be able to facilitate the requests from their B2B customers to make this process easy. Because it doesn't have to be all emails and phone calls. You can set this up as a nice standard secure workflow. It creates an audit log behind it. But fundamentally, I think the driving factor will be, are you a controller if you're the one that got the data? I'm using GDPR kind of language with mostly because everybody on an IAPP webinar understands what I'm talking about.
That language.
Yeah, when I talk to marketing teams, I don't use the word controller. But if you think of yourself as the controller of the data, you're probably on the hook for making sure that happens with all your downstream partners. And we're seeing that happen a lot in the B2B MarTech space. And a lot of those B2B MarTech or ad tech companies, they just aren't set up to interact with people because they're not consumer-facing companies. And so there is a technical set of challenges that you have to think about if you're in that space. So I mean, we've really looked at a maturity curve over the next year, and we think the community should just think about planning a timeline. Get basically on top of it ahead of January 1st. We don't think that there'll be some magical thing that switches on that in those first weeks you're gonna see it. We think it'll grow over the first 6 months. There's going to be a lot of publicity when the regs are finalized. Enforcement's going to begin in July. We see the privacy advocacy community and the CCPA community really ramping up to advertise around the new rights. And then remember, in July, you're going to be in the heat of the California ballot initiative process. That law is polling, the new ballot initiative already is polling above 85%. So all of us are going to be on another webinar, I guarantee you, next year, where we're talking about those changes in CCPA version 2.0 that we're all going to have to think about.
Yeah.
As I've mentioned, we're going to move here. I think we're hitting 11:45 past the hour, so I want to make sure, Dave, if you have questions, we can cover them. On our platform, we do help companies with a lot of these issues, and again, we've directed folks to a demo. The one thing I will say, our outline of all the technical requirements, the resource that's available at that RFP link, Dave, honestly, it's built for both IT professionals and for privacy professionals, and it can add a lot of guidance as you're thinking through these requirements.
By the way, Justin, just so you know, we posted that link in the Q&A panel for those that are wondering. So if you're interested in that link, it's wirewheel.io/RFP, and we've posted that link. It's a live link in your Q&A panel for those of you that are interested in popping over there and bringing up a browser page and having a look at that. Yeah.
Terrific. Well, great. So I hope this was helpful in terms of where we see. I'm happy to answer questions, or I can cover some of the topics we covered in depth as well, Dave.
Yeah, no, this is a great opportunity. Again, we're coming toward the end of the hour here. For those of you that are on the line and listening, there's a field just to the right of the PowerPoint window. Type in your anonymous questions. We'll deal with them anonymously. Submit them here. This is your opportunity to have Justin provide some information for you. And we do have a couple of questions that have come in and that I would like to tackle. Justin, this one has to do with something we were talking about earlier in terms of third-party vendors. It's a question around redoing the contracts with those processors in light of CCPA requirements. Do you think it's a worthy exercise to, pull out these vendor contracts you've got with these downstream processors and having a look at them to make sure that the language is up to date in terms of how they're going to help you as, again, using GDPR language, your controlling responsibilities with your customers? And pretty important to look at the language in those contracts with those third-party vendors, and also maybe go on a little bit to talk about the definition of service provider as sketched out in the CCPA.
That's a great question. If you've done the work under GDPR, then you're probably in a pretty good spot, but you do want to look at those contracts. And for CCPA, the number one thing I would look for in those contracts is anything that is at least a provision that covers you when somebody has made an opt-out request for the sale of data. So remember, if under the law, if a consumer requests to opt out of the sale of the data, you, as the controller, still can do a lot with that data from that consumer, including advertise to that person. That's perfectly acceptable as a first-party company. What you cannot do is transfer that data to a third party and allow them to use it for any other purpose, including surfacing those ads or using, some of the contextualization. So we've really found it to be a valuable exercise to make sure you have a simple CCPA provision, and that's the legal side of things, something that at least makes clear that if you tell them somebody's opted out of the sale of the data, that they're going to treat that data in a segregated way consistent with CCPA, and then to enable your company to enforce that language, you need a suppression list that you can share with your third parties. So technically, you have to capture that information, have it in a way that you can share either directly or via API with downstream parties, so that when a company says, okay, I'm going to follow the rules, you have a way that you can point them to that suppression list to take care of those requirements.
That's great. Let me follow up with you on that, Justin, because we just got a question from the audience that's related. You may have already covered it, but there's a nuance here that I'm wondering if you might want to address. The question is this: do you recommend that businesses add in their contracts with other businesses provisions that require them to process individual rights requests? The way I'm thinking about this, it's almost like saying to all your downstream vendors, hey, if we're going to continue doing business with you, we want to make sure that you all are aware of the CCPA as individual entities upon yourselves, and that you are also honoring CCPA requirements some imagining a scenario where perhaps as a controller, you're doing business with vendors who are not honoring data subject access requests themselves as processors. That's the way I'm reading this question. Any thoughts there?
Yeah, that's again a great question. Yes, and again, having a provision with your vendors that's something like, at least a catch-all, you will comply with CCPA, and if they're a processor for you or a vendor and they're taking third-party information, getting a clear understanding that they will facilitate the exercise of a CCPA right if necessary. Something like that. Obviously, you may need to get advice from your own lawyers about the specific language. That's critical. And then thinking through how you automate this when a request comes in is also critical. You have to be able to push that signal down to those third parties, be able to record on your side that you've done that, and be able to show it later so that you can show that you're handling those requests appropriately. So very important, and a great flag to make sure that your language with folks you're sharing data covers you for these new CCPA rights, both from opt-out or if you have a collection or access request, and then think about some way to automate that so that you're not having to send manual emails and track down when they've occurred.
Yeah, and there's another great follow-up question here. I'm not exactly sure what the questioner is trying to get at here, but let's give it a shot. Does that extend to your third-party service providers? Say if you use a third-party email provider, how would you be able to continue communications with that individual?
So, this is, again, a good question. The whole point of when you use a third-party email provider is making sure that service provider is using the data to fulfill a purpose that is appropriate under CCPA. So here's some examples. If you're I'm trying to think, let's say, here's a good example. Let's say you're a retail brand company, and when somebody makes an order from you, you take the information from them, and let's say one of the consumers has opted out of the sale of data. It's, of course, perfectly appropriate when you take that information for that information to go to an email service and send the receipt back to the consumer. That's accepted. It's within the normal operating methodology. There may be some rubs on this. I'm giving hypothetical examples. I think everybody on the phone understands this. If you have specific legal advice, make sure to run it by somebody. Now, let's say instead of that, what you're doing is somebody opts out of the sale of data, and you're sending it to an email vendor for purposes of surfacing ads that are for another product, right? That is the kind of thing that is likely going to be an issue under CCPA, and that's why it's very important to make sure, even a worse situation would be, let's say the email vendor, when they take the information for purposes of surfacing the receipt, in the first example, the email vendor does their own advertising, right, for their own services. Yeah. All of these would be problematic. You're going to want to make sure that the contract makes clear that if somebody's opted out, they have to treat that data in a very, very specific way, and that they assume the liability if they start doing, treating that data differently. And again, you need to enable enforcement of these provisions with a suppression list and clear contract provisions. Dave, does that help?
It does, absolutely. And as you were answering that, Justin, I was kind of going back to, the kind of common sense approach to the law and thinking about the intention of the CCPA in general. And, the point is a consumer in the resident in the state of California is contacting a company and saying, I don't want my information being shared further for advertising purposes or other, and thinking about putting yourself in the shoes of those consumers and how they would like their information to be used or not used with any of your downstream vendors is probably a good basic rule of thumb. And then, as you mentioned a couple times, very important to get the advice of legal counsel, either internal or external. So we don't have a lot of time, and we're getting a couple good questions in here. I want to see if I can get to several of these before we run out of time, Justin. This is one you and I have tackled before, and we hear very commonly. It's a great question. If a company is a manufacturer and only sells to other businesses, so we're talking B2B here, must it include the Do Not Sell button on its website and comply with other obligations? So lots of folks out there in this situation, they're wondering, I'm not consumer-facing, I'm not B2C, and I just do business with other businesses, and do I still, to be on the safe side, need to comply with CCPA regulations? How do you answer this question? I'm sure you've heard it before.
No, it's a great question, and the biggest challenge for our community is trying to eliminate that you're selling data in your company. So if you go to ask anybody in most of the companies that we work with, they're not actually physically selling the data. But, for example, tracking down all of the third-party information sharing that just occurs from a cookie perspective is often a challenge. I mean, you have to go spend a fair amount of time with your marketing team. You have to go make sure you understand whether any of the practices, your marketing, sales, your entire go-to-market team, and this applies in both B2B companies and B2C companies. There's some really incredible things that marketing and sales teams do with data. Sometimes they're purchasing data, sometimes they're doing information and retargeting on websites. All of that you have to look at before you come to a firm conclusion that you're not selling data within the meaning of CCPA. What we've seen as a practical matter is it's really hard to do that on the window that we're trying to comply with CCPA. And if you have not eliminated that you're selling data, then you probably should put up something on the website that allows somebody to do a do not sell request. So I'm not saying everybody's selling data, but actually making sure you're not selling data, it takes a lot of time. We're a strapped community in terms of time, and so that's often the way we see companies going.
Here's a great follow-up to that question. First of all, good answer, and here's a great follow-up to that question. Very related. This is really interesting. I'm going to guess how you can answer, but we'll let you take a stab at it. The question is, does the opt-out of sale of data have to apply to everything, or can it be obtained specifically related to, particular items, or, for example, could they opt out of selling their data to sponsors for a specific event, but not necessarily all events? So it's a great question. Can you provide kind of a layered opt-out approach to your consumers where they're opting out of certain uses and not others? I'm going to guess that you're going to say that's maybe work for another day down the road. It's complicated, and if you tried to do that and parse this too thinly, you're going to maybe get down into some nasty weeds. But I don't know. What are your thoughts about that? It's an interesting question.
So look, we have ways with our companies that even in the browser you can set conditional actions. As part of our demos, please let us know if you have the specific questions. We can show you how to do it. The way the regs and the law are written is you almost always have to present something simple that somebody can opt out of the sale of all of it. If you do present that option, you almost certainly can present options where they can do more narrow opt-outs if a consumer likes. But you're probably going to have to present both simply. Either I'm opting out of everything or I'm opting out of subversions of it. And there are ways that we can record that in a more automated way if you need to do that.
Terrific, thanks. We have time for just two more questions here, Justin, and I'm going to start with just a request for clarification. You had mentioned a suppression list, and we have a question from the audience about, could you please define what you mean by suppression list?
Sure, and I apologize for just slipping into just a term like that, Dave. I think you and I have talked about this before, so I may reuse something here, but there was an episode of Seinfeld years ago that I loved where Jerry goes to make a car reservation, and they took the reservation, and he starts laughing, and they gave away his car, and he says, you got to both take the reservation, and you have to hold the reservation. What I mean by a suppression list is if somebody says, I'm opting out of the sale of data, sometimes you're going to get from them only whatever information was collected from the browser, things like cookies or IP addresses. Sometimes you can collect more of that. You have to hold that opt-out request somewhere, and that's what I mean by a suppression list. So why will we record a suppression list in a couple of different ways for companies? But you have to have that somewhere that you can actually use to help your company use that data internally, and you have to be able to use that, quote, suppression list to help you enforce your contractual rights. We automate all of that, but that's what I mean by a suppression list. It's a list of folks who have requested to opt out of the sale of the data with whatever information they have given you.
Right, so making sure all the pieces connect. You're collecting that information, doing a great job. You have that list. You have to actually follow through and make this happen, make these deletion or access requests, deliver on those. We had a great comment from the audience here that says the holding is the most important part of the reservation. So,
exactly.
And then let's finish with this one. Sadly, we're out of time. I'm sure we could go on for quite some time here, but this is another great question. Terrific questions from the audience, by the way, in this program, folks. Just really excellent and I think applicable to a lot of people. So thank you for being such wonderful participants here. And so we'll finish with this. Regarding the question on B2B companies and eliminating to sell the data, how does this work for international companies sharing data within the companies within the same group? Might this be considered a sale under CCPA? And I'll do the caveat for you, Justin. Gain legal advice from within your company, but it's an interesting dilemma. A lot of the IPP members are large multinational companies doing business all over the world, and holding companies which have many different business arms. Within those, transferring data within those arms, might that be considered a sale under the CCPA, or what are your thoughts there?
I think it could be, unfortunately, because of the way the law is written. It's hard to make a generalized statement. There's certainly times where it wouldn't be, especially when the consumer kind of thinks of everybody as part of the same solution. I think I wish I could give a better answer, but when I look at it, I certainly think within even a group, it could be a sale of data. What I would say with some of these more specific questions, Dave, our team at Wirewheel is pretty prepared. We've been getting companies up on, a very accelerated CCPA compliance program quickly. Our team is trained to answer these kinds of questions in the more specific. So please reach out through that demo link that you can see on the right, and either, one of our team members or one of our privacy experts can talk through these challenges with you and show you how you can tackle it.
Terrific. Well, with that, thanks so much, Justin. And regarding further questions, we do have a couple that we can get to. You can reach out directly to Justin. His email address has been provided there. I'm sure he can either help you out or direct you to the appropriate people on the team to be able to help with that. And so before you leave us today, you can take a quick quiz for us, please. We're always interested in improving these programs and making sure we're delivering the kind of content that you need to do your jobs out there in the privacy field. So there's a live link in front of you now if you're listening to this program as a live program. If you click on that, you can take a survey. It's just literally 2 minutes long, and that will help us improve these programs. There's a field in that survey that allows you to let us know what topics and issues you're wrestling with that you would like us to focus these programs on in the future. So click on that live link there, take literally 2 minutes, give us some feedback, and let us know what you want to hear about on future programs. And a hearty thank you, Justin, for spending some time with us on the program today and offering some advice and insight. As you mentioned during the program, I'm sure we're going to be revisiting this topic for 2.0 sometime next year. But it was wonderful having the conversation with you. And thank you, Wirewheel, for supporting us here at the IAPP and making this program available for free to all of you out there. So thank you, Wirewheel, and thank you, Justin.
Dave, thanks again.
Yeah, and I wanted to reiterate, as I said at the beginning of the program, that if you're an IAPP certified privacy professional and you're listening live and you're registered through our website, we're going to automatically grant you 1 CPE credit. That's just going to happen automatically. You don't need to do anything toward the upkeep of your certification and your required CPEs. And if you're an attorney and you're wondering about continuing legal education credits, we do not pre-certify these programs, but they are often eligible. So you'll need to put in an application in your particular jurisdiction and see if that satisfies, and hopefully it will. And if you need additional supporting materials, you can contact me directly. My email address and phone number are there on the slide in front of you. Feel free to reach out. Love to hear from you. I'll also mention again that a recording of this program is going to be posted within 48 hours on the IAPP website. I believe it's going to be available as well on the Wirewheel website. And there will be a live link under the recording window, the on-demand video viewing window, a live link where you can download a PDF of the slides. And you can look through these slide materials again. So one last time, thanks everybody for joining us today. It's been a real pleasure, and hope to see you on an IAPP web conference sometime in the near future. And with that, I will bring us to a program close.